Next speaker is John McLemore. Really needs no introduction. John McLemore started out in life as a banner reporter covering the court beat and covered some of the people in this room quite often. Then he became a lawyer and became an expert in bankruptcy and insolvency and other matters, and has served for many years ably as the chairman of the NBA Historical Committee until he got elected to the board and had to resign as the chairman of that august committee. Come on up here, John. I'm going to remind him that 30 years ago, next month, he preceded me in a program the night I was elected president of the Bar Association, and spoke so long that Chief Justice Bill Harbison of the Supreme Court didn't speak until 11 o'clock that night. So, John, we are looking forward to your lucid, informative, and brief presentation.
I don't know that there could be a worse person that you could say, please trim 5 minutes off so that we can get back on schedule, than me. But I'm going to do the best I can to do that. You have heard a lot about what was going on. My job, I was told, was to inform you of what happened at the trial court level in Baker versus Carr. There was no trial. So I ought to be able to do this very quickly. In fact, here's the short version. Suit filed. Motion to dismiss filed by the state of Tennessee. Motion heard by Judge William E. Miller. Overruled. Three-judge court impaneled. Motion sustained. And the case went to the Supreme Court. What I'm going to talk to you about very quickly is what happened in 1959. The case really began on October 16, 1954, before Kidd versus McCandless. It happened the day that Boss Crump died. You have heard the discussion about the Crump machine maintaining its political inertia, and that lasted for a while. But then the rural legislators who Crump had controlled realized that they had the power and that there was no one really, no great successor to Crump, and that they could do what they wanted to. Also, Crump's base was in the Republican Party in East Tennessee. And they had lost their power completely as a result of the death of Crump. So the Crump's machine was considered to run from the Tennessee River to the Mississippi River. And those legislators began to starve Memphis. In 1958, David Newby Harsh, who was head of the Shelby County Commission, and let's get this clear very quickly, Shelby County had a three-part governance. The Shelby County Commission, the Shelby County Quarterly Court, and then Memphis had a 5, I believe, commissioner system. They didn't have a mayor. They had a 5-commissioner system. Well, they did have a mayor, but it's complicated. But those were the three governmental units in Memphis. David Newby Harsh, who was the head of the commission, of the county commission, called Walter Chandler. He called him for a reason. Walter Chandler was former mayor of Memphis. Walter Chandler was a former congressman from that area. Walter Chandler was a former legislator from that area. And Walter Chandler was one whale of a lawyer. For those of you who practice bankruptcy law, if you've ever heard of the Chandler Act, it's Walter Chandler Act. He did something that he did while he was in Congress, and probably the biggest thing from that was Chapter 13. And so Harsh looks at his new lawyer, at Chandler, and he says, "Can we get into the federal court? I'm reading about what's going on in Minnesota, and I think we might have a chance." And with that, Walter Chandler went to work. And again, you understand, having heard Frank Grace, that the federal court case was a due process, equal protection clause case. Was the failure of the state to reapportion under its own constitutional requirements a violation of the 14th Amendment to the Constitution? Chandler went to work. First thing he did was find a team of lawyers. Now, you have just seen Harris Gilbert, and he ended up on that team. But at the beginning, Hobart Atkins in East Tennessee, in Knoxville, four-time state senator, veteran of Kidd versus McCandless, number one choice. Number two, Z.T. Osborne Jr., rising star in the Nashville bar, brilliant lawyer, and also a veteran of Kidd versus McCandless. Next thing he had to do, who's going to sue who? Where does Baker versus Carr come from? Baker was the chairman of the Shelby County Quarterly Court. Carr was the Secretary of State of Tennessee. They did not know each other. They did not meet until 4 years after the Supreme Court ruled. The case wasn't about them at all. It was about Walter Chandler and the lawyers who he put together building this lawsuit. They didn't have a client. Next thing they had to do, get a good legal theory. Well, you've heard about some of the legal theories. I'll throw another one in for you. They drew off of Brown versus Board of Education. It was pretty simple for them. If a man cannot be denied equal treatment because of race, why can he be discriminated against based on where he lives? And the pleadings, they called it a purposeful and systematic plan to discriminate against a geographic class of persons. Next thing you got to do, where are you going to try this lawsuit? Got a great big state, 500 miles long. And there were two reasons to come to Nashville. Reason number one, legislators sat in Nashville. If they could get the case tried, and boy, they wanted a trial before a 3-judge panel just like they had gotten in Minnesota. I hope you all understand that. The Minnesota case was tried not before a United States District Court judge. It was tried before 3 judges, 2 U.S. District Court judges and 1 judge from their local circuit. They wanted that. That was going to be, for them, opening in New Haven before going to Broadway, because they knew Colgrove versus Green had to be upset. They were going to the United States Supreme Court. Before this case was filed, they were going to the United States Supreme Court. And they thought that way about it. So the second reason for coming to Nashville, U.S. District Court Judge William E. Miller, 51 years old, 1955 appointee of Eisenhower. He had come out of East Tennessee, not unlike L. Clure Morton, who we all remember. And he knew what was going on in East Tennessee with Knoxville and Chattanooga. He also knew what was happening to the Republican voting districts in East Tennessee and how they were being discriminated against by the rural legislators. He was tough. He had already had cases involving the UMW, and he had taken on the first Nashville desegregation case. This is something that Chandler really liked. And Chandler was watching very closely Miller's handling of a motion to set aside a jury verdict in the income tax evasion case of Chattanooga Teamsters head Glenn Smith. Now, I know everybody out there who knows me is saying, uh-oh, McLemore's going off on a tangent. And it is a slight tangent, but it is crucial to Baker versus Carr. Judge Miller, the state of Tennessee had been shocked by Smith's testimony. Number one, he took the witness stand in his own criminal trial. He got up there and he said, "Judge and jury, I'm not guilty of income tax evasion. The $18,500 that you say should have been on my income tax return shouldn't be on my income tax return. It wasn't my money. I was a conduit for it. It's very simple. I received the money. I took the money down to criminal court Judge Ralston Schoolfield in Chattanooga and smoothed over a couple of criminal matters involving some of our Teamsters people down there. This was stunning testimony. And there's a motion, 13th juror motion, following his conviction. Your Honor, our man is not guilty of income tax evasion. And Chandler's watching this and saying, watch Miller. Miller is going to upset the jury verdict. And he did. And Chandler interprets this as, we've got a maverick. He probably should have interpreted it as, we have got a strict constructionist. But nonetheless, you want to know why that makes a difference? I think we've got a clip at this point. Hooker, we do not? We're going to have it later. You're going to see a clip later that will show you why that wasn't that bad of a diversion here. So he's got the team together. He's got the court. And let me say this as I proceed through this. At that time, no one recognized then, but the cases involving the Teamsters Union were going to engulf the U.S. District Court for the Middle District of Tennessee like a fog, impacting everything it touched. And John J. Hooker is going to explain to us the connection there. Just as soon as the case was filed, Allison Humphreys, Solicitor General of the state of Tennessee, steps in. Colgrove versus Green. Colgrove versus Green. You can't do this. And he files a motion to dismiss. We've got Atkins and Osborne going before Judge Miller. And Atkins says, look, Your Honor, 4 of the justices in Colgrove versus Green said that there was jurisdiction. Now, wait a minute. Why would that make any difference to anybody? There are 9 people on the Supreme Court. 1946, Justice Robert Jackson is prosecuting in Nuremberg. And Harlan Fiske Stone, the Chief Justice, is listening to the arguments in Colgrove versus Green, suffers a heart attack, dies a few weeks later. 7-man court. The scholars call Colgrove versus Green a 3-3-1 decision, and you heard Harris Gilbert explain that. 4 of them said there was jurisdiction, but 1 of them flip-flopped and said, yeah, but we're not going to use it. So, Atkins is arguing that, followed by Osborne, who says, who takes on the political thicket argument. I don't think anybody has said what the political thicket barrier was, and here is exactly what Justice Frankfurter said in his opinion. Courts ought not enter the political thicket. The remedy for unfairness in redistricting is to secure state legislatures that will apportion properly. Or they could invoke the ample powers of Congress. But don't come to us and whining about what the legislature's doing. We're not going to order the legislature to do anything. This was countered by Osborne, who goes back to the founding of Parliament in his argument, and he says, when Parliament was founded, it won from the king the right to seat its members. But before Parliament was founded, the people won from the king the right to have a parliament. The legislature belongs to the people, Osborne argued. It does not belong to the individuals who comprise the legislature. And he says this idea is carried through to our United States Constitution at the 14th Amendment. Miller overrules the motion to dismiss and calls for the appointment of 3-judge panel. The panel is made up of Miller, 6th U.S. Circuit Court of Appeals Judge John Martin, U.S. District Court Judge Marion Speed Boyd. Martin and Boyd are both from Memphis. Martin and Boyd are both cronies. Martin and Boyd are both very conservative. Chandler is very upset with the panel. When great men do great things, little is ever said about how they get compensated for it. Just the fact that they do it should be just compensation. But both Atkins and Osborne had put tremendous intellectual and professional capital into Kidd versus McCandless and now into Baker versus Carr. And they needed to be paid. That's what was so important about Mayor West coming into the case, because when he came into the case, and Harris Gilbert didn't say this, but I think it's true, he wanted to come in as an individual citizen. If you go to the archives of the library here, you can read, and he put it in the complaint that he wanted to file. He talks about his children as being students in the public system and how they were being cheated. And somebody has to sit down with him, Harris, one of them, and say, Mr. Mayor, there is no way on God's green earth that the city of Nashville can find a way to pay for a private citizen's lawsuit. You got to be the mayor. And so he decided he would be the mayor, and he brought money into the case that got people paid. The fee for the Supreme Court lawyer who we'll hear about in just a little bit was $20,000. It's a flat fee that was paid by the city of Nashville. But this was very, very important. Also, bringing in all the research that West brought in. Chandler also brought in the state historian, who did incredible work on how there was a systematic attempt to prevent any reapportionment for decades. And this was very, very important. Now we're going to go to the hearing before the three-judge panel. Chandler, Atkins, and Osborne hammered away in support of jurisdiction. 4 of the 7 justices in Colgrove versus Green had said the court had jurisdiction, and Humphreys countered that when the votes were finally counted, 4 of those 7 justices held the cure was worse than the disease. The plaintiffs argued there was relief that the court could easily grant if it was found at trial that the legislature would not reapportion. Then the court could order a statewide at-large elections. Give that some thought. Statewide at-large elections for the Senate and the House of Representatives would have completely flip-flopped the situation. The cities would have elected everyone, and there would have been no rural representation. But Osborne argued, if chaos results, it's preferred to tyranny. Now, let's look very quickly at what had Thomas Wardlaw Steele done in Kidd versus McCandless. His ruling is like reading Chinese. I'm almost there. But basically what he did was rule that the legislature, the General Assembly of the state of Tennessee, is a de facto General Assembly. It, in fact, is a General Assembly. It sits up there. Those are human beings. But it is not a de jure General Assembly. Therefore, anything that it does following my ruling can be attacked as being illegal because the General Assembly is not properly constituted. But this idea of how are we going to fix this was a big problem. As the arguments continued, questions and comments came from the bench. It became clear the court was hung on the issue of states' rights. Sixth Circuit Court of Appeals Judge John D. Martin. There are still some of us who think that the dual system of government established by the Constitution should be preserved and federalism should not run riot to the deprivation of the fundamental rights of the states. Atkins counters. If the state legislature were down in my pocket taking my money, I could come to the court and the court would stop it. But here, they are not taking my money. They are taking something more valuable to me. Now, do I understand that the court should look the other way? The bench. No, not look the other way, but not look at all, because it is no business of this federal court. This is my position. We haven't any right to direct the legislature of Tennessee to pass a law. There was not much discussion, or there was much discussion of Colegrove versus Green, whether it was good law or bad, but everyone had to agree it was the law. In an exchange with Humphreys, Judge Miller said it was clear to him that the provisions of the Constitution of Tennessee regarding apportionment had been disregarded continuously and systematically for years, but he could not envision a court-ordered solution to the problem. He even discussed the possibility of the election at large. Judge Miller. But suppose this court would so declare this law unconstitutional, and then direct an election at large, and then suppose the legislature so elected would convene. I suppose the theory would be that the legislature would enact a statute that would meet the requirements of the Constitution. But what assurance would there be that the legislature would revamp the state or redistrict it? That is the difficulty I'm having. My problem in this matter is the problem of a proper remedy. I can see the wrong of the thing, but I can't see how to right it. In closing, Chandler told the three judges that Colegrove versus Green was not good law, and then he said the words that for which he will always be remembered: no case is ever decided finally until it is decided right. For the plaintiffs, the battle was lost. The court issued its opinion on December 21, 1959. Its order would come down 45 days later. Next stop, the United States Supreme Court. Just as the death of Boss Crump had set in motion the events that would lead to the filing of Baker versus Carr and eventually the right decision, the one that would cause reapportionment for every voting district in the nation, there was another wind blowing. The proverbial butterfly had flapped its wings in 1957 during a hearing before the Senate Permanent Subcommittee on Investigations, when Teamsters President James R. Hoffa told Chief Counsel Robert F. Kennedy that he was nothing but a rich man's kid who never had to earn a nickel in his life, and all-consuming, no-holds-barred war began. Many of its battles would be fought in the courts of Tennessee, beginning with the impeachment of Judge Ralston Schoolfield and the conviction of Hoffa for jury tampering before Judge William E. Miller. One of the geniuses and heroes of Kidd versus McCandless and Baker versus Carr, Z.T. Osborne Jr., would be engaged as defense counsel for Hoffa and would not survive the war. He, along with his client, would be indicted, convicted, and sentenced. His case would be appealed to the U.S. Supreme Court. His attorney would be the World War II veteran and former freshman state representative who just wanted the legislature to follow the Tennessee Constitution, Macklin Davis.
Well, I take back everything I said. I could have listened to more of that. We do have a break coming up. Oh, it's all right. It's the art of the rhetorical statement. But I'm serious. That was great. Now, he has really set us up for the second half of this, because we have the aforementioned Mr. Harris Gilbert. We have John J. Hooker. We have Judge Gilbert Merritt, who were right in the thick of this back in the late 50s and mid to early 60s. So I think you're really going to enjoy it. We're also going to meet a member of the Baker family and hear a few other local connections. So let's take a 10-minute break and be back in your seats, please, promptly in 10 minutes.